Further hearing of the appeal, UBS, JCPC, New York and others.
Mr. Moss.
May it please the Court. Yesterday we were at the point where we mentioned Judge Bernstein's judgment, where he cited the ECCA decision. We submitted that that is also a reference to the ECCA's discussion of the American cases that we've shown the Court. Perhaps I can give the Court the references. The ECCA judgment cites the Atlas case that we mentioned yesterday and the Condor case at paragraphs 68 and 69 of their judgment, and that's the record, volume 1, tab 18, pages 208 and 209. The ECCA then cites Hellas too at some length, including a quotation, at paragraphs 73 and 74. Mm-hmm. The reference to that is record, volume 1, tab 18, pages 211 and 212. The other, I can go to those if the Court wishes, but I thought perhaps giving the citations would be sufficient.
Yes.
The other thing we mentioned yesterday was that Judge Bernstein also, of course, had before him very detailed submissions from both sides. And we looked at the submissions overnight that were put in on behalf of the liquidators. And if the Court wants to see copies of this, apparently UBS have brought along some copies, which they were keeping in reserve in case they needed to show the Court. But just to give you the references, the written argument before to Judge Bernstein cited Hellas 2 at page 34, and Condor, Hellas 2, and Metzeler, which you may recall is the Section 304 case, at page 35, footnote 42. It's quite a lengthy footnote. So what we say is that Judge Bernstein obviously had before him, had in his mind not only the decision of the ECCA, but the substantial US case law, which pointed to the same result from which the ECCA themselves had relied on.
Would one describe the US approach as unmodified universalism?
In a sense, yes, because it is more universalist to apply the foreign avoidance law, because that ensures equal treatment for all creditors. So every single person sued for a preference on the value, if the country in which they're sued followed the American approach, then they would all be judged under the same law. Mm.
Under Chapter 15?
I'm sorry?
Under Chapter 15?
Under Chapter 15,
as opposed to the other
two, by the US courts. The difference between Chapter 15 and say, Section 426 is that Section 426 spells things out expressly, whereas Chapter 15 doesn't, and is therefore dependent on the interpretation of the US courts.
Thank you. Now,
as the Court is aware, the liquidator's argument is that there's no basis for an anti-suit injunction. These matters can be left to the US judge to decide, and he has made a decision. And it's not part of this Court's role to act as a kind of de facto appellate court or check on the US law decision made by the US judge. If we were wrong about that, then, and if you're lordships and my lady decided to get into US law, which we don't in any way encourage, then we say that the learned judge came to the right conclusion, and that is that, as interpreted by the criteria used by the US courts, the BVI statutory provisions do not prohibit the use of the avoidance powers by foreign courts, and that the provision in any event is a procedural and not a substantive provision, and is therefore not in any way binding on the US courts. The appellants seek to characterize the procedural substantive question as one of BVI law. We submit in our case that in fact there is no such issue under BVI law. So it's not meaningful to talk about the difference between procedural or substantive in relation to the definition of court. And therefore it's not even in BVI law, it's not a question that arises or is worth considering.
Is it really a question of substance and procedure, or is it really a question of, is there a rule of public policy in BVI law which would prohibit lending any assistance?
Well, there's two parts to it, I suppose. There's a question, is there an implied, certainly no express, is there an implied prohibition on foreign courts using the avoidance powers? And then secondly, is that prohibition, if there is one, categorized as procedural or substantive? But neither of those questions are really of any interest to the BVI courts. They've never come up, and they seem to have no practical relevance. And therefore, there's nothing under BVI law, we submit, that requires to be dealt with by this court. If despite all that, the court wished to embark on this kind of issue, then we say that there is no prohibition under BVI law, and that the definition of the court in the avoidance provisions is simply designed to indicate which BVI court the claim is to be brought in, and is therefore a procedural matter. There is nothing in the language, there's nothing in the history, and there's nothing in the context of the statutory provisions in the BVI which suggests any prohibition. However, we do a rather fuller analysis in our case, which perhaps I can take the court to at this stage. And that's in the documents bundle at 85. That's our case. Page 3370. Set out in a separate Annex 1, a detailed analysis, starting with what I think both sides accept is the original provision, the model, and that's the English provisions, and then going on to look specifically at the BVI provisions. And so for this purpose, the court may want to have the UK and BVI legislation to hand. UK version is in A6. Look at that first. It starts at 4897. following it through in our annex, if I may, the relevant provisions and ancestors of the BVI preference and undervalue provisions are sections 238 and 239, as the court has already heard. In terms of the definition of the court, these sections don't have separate definitions because they're part of the corporate insolvency part of the Insolvency Act, UK Insolvency Act, and they fall under the general definition of court in section 251. Go to page 4962. There's a definition of the court in the middle of the page in relation to a company. It means the court having jurisdiction to wind up the company. So it tells one to bring one's undervalue or preference claim to a court which has jurisdiction to wind up. That general definition, as I think I said yesterday, does not apply to section 423 for reasons which I explained. Now, jurisdiction to wind up takes us to sections 117 and 118, which are at the beginning, page 4897. Can I invite the court to read 117 and then 118, which is on page 4899. Essentially, what this says is that High Court, being a court of record, has full jurisdiction over the entire field, but in certain circumstances, one can go to one's local county court, which is perhaps closer and cheaper in many parts of the country, and have insolvency matters dealt with there. But this is not a limit on which courts one can go to. These are provisions designed to extend the types of courts that one goes to. But it provides what the Americans call the venue provisions, the courts that you approach. And as one can see, even if you start in the wrong court, there's still jurisdiction, according to 118. And you don't even have to transfer out to the right court. So this is not jurisdiction in the full sense, this is venue. Now then, starting at paragraph 8 of our annex, we have a section which explains the differences with section 423. And I think I explained yesterday, I don't want to repeat, special features of 423, although it's also based on undervalue, can apply to both corporate and personal, can apply to insolvency proceedings, non-insolvency proceedings. And therefore there are slightly different definitions, special definition of court, which again enables people in corporate cases to go to certain county courts, in personal insolvency cases to go to certain county courts, and of course always to the High Court. And again, it's a way of expanding the number of potential courts, not restricting them. Can I invite you just to read what we say about the Banco Nacional de Cuba, sometimes called Banco Carige, in paragraphs 12 and 13. We don't say that's exactly in point, but it does give an indication what we say about all this being procedural. Now, not far along from Section 423 is Section 426, which we mentioned before. But Section 426, the Court may recall, is an international cooperation provision limited to a list of designated countries, which are mostly Commonwealth and mostly English law-based countries. But what's interesting for present purposes is that it expressly allows the English court to apply either English law or foreign law. And our submission here is that given that Parliament expressly provides for our courts to apply the foreign law, it's one possibility, must have envisaged that those foreign courts might well decide to apply our law. And therefore, it is completely improbable that Parliament would have thought they were impliedly prohibiting foreign courts from applying English insolvency law, including, of course, avoidance. The next point of paragraph 16 is that there was a thorough review of insolvency law, which led to the Insolvency Act 1986 by Sir Kenneth Cork and his committee in the Cork report.
Just before you leave 426, when did it originate?
426 is a recast of Section 122 of the Bankruptcy Act 1914. And in the Grupo Torres case, which is somewhere in the authorities, was held to have similar effect.
And did it right back to 1914 include the ability to use the
As interpreted by this court, yes. Whether the words actually spell that out or not is a matter of some dispute, but yes. So there was a comprehensive review in 1982. This led to a white paper, which was actually blue, which accepted some of the recommendations of the Cork Committee. The only reason we mention these is a negative sense. If there had been the kind of change which the appellants suggest, just by having the newer type of wording for avoidance instead of the old type of wording, referring to applications to the court and so on, one might have expected that the thoroughgoing review or the white paper might have said something about it. So we make the negative point. As far as we can see, there is nothing either in the Cork report or in the white paper which suggests this kind of change was meant to take place in the redrafting of the provisions, including the preference provision. The undervalue provision, of course, didn't exist before. Section 423 is also, in a sense, a redraft because its predecessor, as Lord Falconer said, had been Section 172 of the Law Property Act, 1925. So, concluding in relation to the English law position, in our respectful submission, there is not the slightest basis of any kind for implying any sort of prohibition on foreign courts using English law remedies in the Insolvency Act. Then we come to the BVI. Here it's Authorities, Volume 5. Has the BVI 2003 Act, where these provisions, as both sides agree on, modelled very largely on sections 238 and 239. Although the BVI draftsman has made some changes in terms of drafting style, the substance is the same. In fact, invite the Lordships to read paragraphs 18 down to 25, try and draw parallels between the two sections of drafting. Now, the appellants have emphasized at all three levels, and indeed seems to have put at the center of their case, the fact that the BVI section 249 provides a remedy, but the earlier sections, 245 and 246, don't. That somehow makes some kind of critical difference. And in our respectful submission, that's not right. This is just a drafting technique. In the UK provisions, 238 and 239 set out a general remedy. And then later on, section 241 sets out what I call a shopping list, a set of specific remedies without prejudice to the generality of the general remedies. Whereas the drafting technique in the BVI is that 245 and 246 don't set out a general remedy. They describe the offence, as it were, the undervalue and the preference, together with earlier sections. And it's only 249 that sets out the shopping list of potential remedies. In our respectful submission, this is not a material difference of any sort. It certainly is not a basis for saying that there's some kind of implied prohibition. In each case, the relief, of course, is discretionary to an extent, although we would submit rather limited extent if the statutory criteria have been fulfilled, unless, for example, the defendant has no connection with the jurisdiction. It's difficult to see the discretion being exercised in a way so as not to give a remedy. But the fact that there is a discretion in any event does not undermine the point that there is no reason to imply prohibition on use by foreign courts. So going back to section 426, for example, that, in accordance with the interpretation of the Court of Appeal, is also discretionary to an extent, and yet it's obvious that Parliament expects foreign courts to use English law just as it expects English courts to use foreign law. Now, just going to the definition of court at our paragraph 26, and the mention of the court in section 249. The BVI Act, I have to go to section 2 at the beginning. And that's on page 4626, about a third of the way down, means the High Court. Now, in the BVI, there are also magistrates' courts. So by defining court as the High Court, tells you that these kinds of applications are to be made in the High Court and not the magistrates' court. Although the magistrates' court sounds highly improbable even as a possibility, there are actually some Commonwealth jurisdictions where magistrates' courts do have civil jurisdiction. I happened to look up Guernsey, and I noted that the magistrates' courts do have some civil jurisdiction. Now, interestingly, the definition of court contrasts with the other definition to do with courts, which is Virgin Islands Court. And we can pick that up again in section 2 at page 4628. Virgin Islands Court, near the bottom of the page, means any court having jurisdiction in the Virgin Islands. So this time it includes the magistrates' court. So the legislator is quite clear as to what he means, and he defines it quite clearly. And we see that where magistrates' courts are meant to be included, this definition is used. So we can go to section 8. Which deals with insolvency of a foreign company. And in 8.2b, executional process, decree or order of Virgin Islands Court, which would include the magistrates' court. Can then go to, what? Right, 8.1b is in relation to the company.
Yeah.
I'm sorry, that's also got Virgin Islands Court too. And C is individual. And I'm sorry, 2 is individual. And then if we go to 52.2, section 52.2 at page 4650, again includes magistrates' courts in relation to this stay to do with the moratorium.
Yes, if you read it along with 51, for example, the application for a moratorium has to be made to the High Court.
Yes,
Yeah.
exactly.
Yeah.
So you have the contrast there between 51.1, the court, High Court, and then the stay applies to any Virgin Islands court or any tribunal in the Virgin Islands. Should include the magistrates' court. And then 174.1b also a stay power.
Could I have the page number, please?
Oh, I'm sorry. 4708.
Thank you.
Again refers to any other Virgin Islands court or tribunal in the Virgin Islands. So the BVI legislator is clearly conscious throughout this statute of the two different definitions. One, the court, which means the High Court, and Virgin Islands Court, which includes High Court and the Magistrates' Court.
It's interesting, the, in 1471A, we can...
147.
In section 17, I beg your pardon, in section 174,
Yes.
we see that the court is distinct from the Court of Appeal.
Yes.
So if section 249 is taken to give an exclusive power to the High Court, it would follow that the power under section 249 couldn't be exercised on appeal.
Yes.
I mean, unless there's some provision elsewhere that enables it.
The Court of Appeal can exercise all the powers of the High Court.
Get it?
I can't guarantee that there may not be a provision somewhere else
Yeah.
on this. Now, the next point, which we make at paragraph 29 of Annex 1, is that where the draftsman, BVI Act, wishes to refer to foreign courts in relation to preferences or undervalues, it does so expressly. So I invite attention of the court to 2453. Yes, I've got it. It's 4735. In relation to preferences, a transaction may be an unfair preference, notwithstanding that it's entered into pursuant to an order of a court or tribunal in or outside the Virgin Islands. So where the draftsman's thinking, I want to include a foreign court in something, then I will set that out expressly. And 2463 on the same page, likewise, for undervalue.
But it's not thinking in terms of conferring some kind of jurisdiction or giving some kind
No. Well, no one does that. I mean, no statute I've ever come across in one country try to confer jurisdiction on one another. The issue here is that it's suggested there's a prohibition. Now, there's no express prohibition, we can see that. So where do they get the implied prohibition from? And I'm putting to the court various points which suggest that in fact, rather than pointing to an implied prohibition, everything points away from an implied prohibition, including the fact that the draftsman is fully awake to the fact that foreign courts may be involved and make special provision for them where he feels he needs to do so. So let us just suppose that the legislature had some terrible brainwave and thought, let's ban the foreign courts from exercising our preference and undervalue provisions. It would be very easy to adopt the same technique and make a specific preference to banning other courts. Other courts are not to use these provisions. But they haven't done that. And in fact, I don't know of any court in the world that has expressly done that. But here, since the draftsman is thinking very clearly about foreign courts, he obviously would have done that. That's our point.
You mean any legislature in the world rather than any court?
Yes. The next point is analogous to our Section 426 point in relation to England. That's if we look at 467. The curiosity here was that my friend Lord Faulkner took you to several sections, what one might call the answer trial model law part of this Act, which, as he admitted, is not in force. Quite how the court is being expected to interpret parts of this statute by reference to parts which are not in force. I'm not sure. But let's look at something that is in force, which he didn't take you to. He did? Oh, he did briefly, yes. Which he briefly took you to, and that is Section 467 on page 4828. And this is the approximate equivalent of our Section 426. And perhaps I can invite the court just to read the whole of 467. And it's worth reading also 468, and in particular 468(1) little c on the same page. This is not an exact copy of Section 426, but it's along those lines. But interestingly, and I think this is borrowed from the old Section 304, one of the aims of this provision, according to 468(1)c, is the prevention of preferential or fraudulent dispositions of property subject to foreign proceedings or the proceeds of such property. So the BVI courts have power to assist foreign insolvencies and exercise their various powers in relation to that. And under 467(5), they can apply either the foreign law or their domestic law, just like in Section 426. Now, we really make the same point as we made in relation to Section 426. If the BVI legislature is saying that the BVI courts have the right to apply the foreign law, then they must be expecting that the foreign courts may well be applying BVI law.
Do we know anything about the drafting process of this?
I can take instructions.
I only ask because, I mean, it strikes one as not beyond the realms of possibility that the draft...
Oh, absolutely, and that's undoubted. But I can ask you about the specific process of... But I can only tell the court on instructions that there is a draftsman somewhere who looks at various statutes and borrows bits of them. And that's how BVI law seems to be made. But this is, whoever has drafted this has clearly been reading Section 426 and probably Section 304 as well. Perhaps the model law too. Although for the model law, of course, we have a whole section earlier which is not in force.
But I don't like to interrupt. I asked the very question that Lord Briggs asked. The only assistance I could find in relation to it is if you look at 138, and my friend Mr. Moss has referred to this, Section 304 is Section 304 of the American Code, not the UK Code that they draw on for 468. I couldn't find where it sprung from, 467. The only thing I can refer to is that although 426 is similar, there's no reference to request in 467 in the BVI Insolvency Act, which may or may not be significant. But it's not quite 426 being drafted into 467.
I mean, they're obviously taking the Act as a whole, all sorts of
Exactly.
departures, I mean, whether they're simply somebody darkened room, fresh, looking at the various options and choosing.
Yes, it looks as if somebody, exactly as Lord Briggs is saying, is doing a cut and paste job with a number of possibilities and putting them together and not putting them together in a way that necessarily makes the complete whole that may exist in other statutory codes.
Mr. Moss.
The request aspect originates right back to Section 122 of the Bankruptcy Act 1914. So the UK draftsman copied that aspect from there. The other types of cross-border assistance statutes simply rely on a request from a court or from a foreign representative, usually a foreign representative. It's more common, but don't specify that there has to be a request from the foreign court. Of course, there can be, sometimes is. So there is a sort of historical antecedent point there. But whoever drafted this clearly thought that was it's not necessary to specify that it should be the foreign court who's doing the requesting. But what one comes back to our point, which is that the BVI legislature must be taken to have considered that since they were giving powers to the BVI court, to foreign law, foreign insolvency law, that the BVI insolvency law may well be applied in the foreign jurisdiction as well.
Yes, I mean, the reason my question was simply that if they had 426 on the table, they know that.
Yes.
Wouldn't just get there by an assumed reciprocity.
Yes. There's no, even
What
under
may also be interesting
426,
is 4681D and E, there seems to be provision for taking account of BVI public policy and also comity.
yes.
So they seem to, in their approach to foreign requests or a request by a foreign liquidator, they are allowing themselves to look at the nature of the distribution that they're being asked to assist, and also they're having regard to comity.
Yes.
Because I think it was being suggested against you by reference to the ZI Corporation that you look at the language, you look at comity, you look at public policy. And it seems that at least two of these three are covered in 468.
Yes.
Yeah, subsection 3 as well.
As well.
Yes, so those, again, I think it's probably borrowed from the old US Section 304. One would expect the foreign court, in deciding whether or not to apply BVI law, to have similar considerations as well.
Is there a BVI predecessor to 467?
Not that we're aware of. Yeah. We think that probably at some point Section 122 of the Bankruptcy Act 1914 must have applied, because that was an imperial act. And in the Grupo Torres case, it was held that although it had been repealed for the United Kingdom, they had not succeeded in repealing it for the Cayman Islands. So in that sense, it's almost inevitably at some point during the imperial period, Section 122, which has now been held by this court to have the same effect as Section 44, would have applied in BVI.
You keep referring Delphically to this.
Sorry?
You keep referring Delphically to the decision of this board.
In Grupo Torres.
Oh, Grupo Torres, yes.
Yes. It's in the bundles.
Thank you.
Well, it's not in the bundles, actually. It's in the additional bundles, and I can hand out the additional bundles. And you can look at them.
I think it would...
You objected to the Privy Council seeing the case.
It would irreparably damage Bologna Friends' reputation to be known as somebody who sends around hundreds of pages of extra material at 3 minutes to 6 on a Friday afternoon. So I'm not going to agree to that. But we can send your lordships the reference.
Yes, the citation will do.
Citation. Sneak a look at the forbidden document. It's 2005, UKPC 1.
Yeah.
We should be looking at this.
We don't want to.
No.
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 No, we don't.
Thank you very much.
If I invite the court, please, to read paragraph 30, which is on the subject of section 467. And then it points out towards the end the potential models, and we've seen evidence that these were probably looked at by this chap in the dark room or whoever it is. Obviously, he's been looking at 426, and we would respectfully suggest he was obviously looking also at section 304, because he's actually copied some of the language. And in accordance with the Metzeler, which we referred to, Metzeler interpreted the language of the old section 304, which has been copied here, as being language which not only permits but mandates the use of the foreign avoidance law, not the US avoidance law. The paragraph 31, something I think I dealt with yesterday, and I wasn't going to go over all that. So in conclusion, what we would say is that if there were a BVI law construction issue here, in our respectful submission, the construction is very clear, and that is that there is no prohibition on foreign courts using BVI insolvency provisions. And that the reference to the court, rather than being intended to create some kind of prohibition, is actually what the Americans call a venue provision, telling you which court to take your case to. And is in fact, as we've seen, at least in England, expansive rather than restrictive. Although in the BVI it's restrictive in the sense that it's High Court, not Magistrates' Court. Then, if I move away from that subject, unless there's anything else I can assist the court with, I was going to go on next to the question of abuse, very briefly, relatively briefly. We have submitted below, and we submit here, that these appeals are an abuse of process. We say that for the following reason. We say that the basis of any litigation is the idea that the litigant who voluntarily participates agrees to submit, subject, of course, to any appeal, but agrees to submit to the judgment of the court. Now, neither the appeal to the ECCA nor in the appeal to this court are the appellants actually agreeing to submit to the judgment of either the ECCA in that case or this court. And the reason for that is that in each case, they are running parallel proceedings in the United States which are ongoing. And in each case, they've reserved the right, if they lost in the ECCA, or if they lose now in the Privy Council, to continue to litigate the same point in the United States with a view to getting a different result. So, in effect, the appellants are said to the ECCA, and they say to this court, we don't really care if you find against us. We will just run that we or our allies, if we have some kind of issue estoppel, the other 700 defendants, we will run the same points in the United States in order to try and get a different result. It's an unusual case of abuse, but in our respectful submission, it is abuse nevertheless. A litigant should not appear in appeal before the ECCA or here unless they're prepared to abide by the result that the court gives.
There's presumably nothing to stop someone who's seeking an anti-suit taking defensive steps in the foreign jurisdiction.
That's true.
Your point isn't that that's happening,
No.
but that regardless of this board's ruling,
Yes, that's right. And before the ECCA, we hadn't yet had the judgment in the States, but there had been what they call full briefing. All full written arguments had been put into the judge, and they'd taken full part in that with the other hundreds of defendants. And yet they were making this collateral attack in the BVI, so that they get 2 bites of the cherry instead of 1. And that we submit as an abuse. We haven't been able to find any direct precedent for that particular point. But as a matter of principle, we say that is wrong. And as the court may have seen, the ECCA certainly had some sympathy for our view, although they didn't finally come down in our favor as an actual judgment on that point. Now, I was going to deal next with the question of the declaration that's now being sought. And we say that declaration should not be, quite apart from the fact the declaration is wrong, it shouldn't be granted as a matter of principle. First of all, it wasn't in the original application. Secondly, it wasn't asked for in the ECCA. And the result of those 2 points is that it has not been considered in any of the courts below. Thirdly, it would amount to acting as a de facto US appellate court from the US judge. Fourthly, it's an issue that concerns US and not BVI law. Put down as fifth that the declaration they're seeking would be wrong. Wrong answer. And sixth point is that if, despite all that, Lord Falconer charms this court into deciding to make a declaration, then we would urge the court to declare that BVI law does not prohibit the US courts from using BVI law avoidance provisions, and that the reference to court is procedural.
Is there another point, namely that the request for a declaration is really a challenge to the liquidator's decision, for which the liquidator has the permission of Mr. Justice Bannister, and therefore amounts to an application by a, quote, busybody in the liquidation, administration of the liquidation.
Absolutely. I might recall that yesterday I made that as a separate
Indeed you did.
point.
I just thought
it certainly comes in here as well, too.
Yeah.
Now, the appellants refer to a series of company internal management cases, and I think I made some submissions about that yesterday, particularly the Xi Corporation case. These all seem to be about the Alberta Court of Queen's Bench, but they're all cases about internal management and, as part of domestic company law and not international insolvency law. From an American point of view, of course, they are not in any way in point and were distinguished by US judges, for example, in Hellas too, because they don't involve an interpretation of Chapter 15 or the use of power in Chapter 15 of the US Bankruptcy Code. So this is company law being attempted to be applied cross-frontier without a statutory basis for applying the foreign law. Quite apart from that, these cases are very, very far away from cross-frontier insolvency. They're best explained, we would submit, as cases where it's inappropriate for a foreign court to deal with the company law relating to the internal management of a company incorporated in another jurisdiction. Doesn't actually have, they don't actually have to hold that there is an implied prohibition. We expand on this somewhat in our skeleton. That's in the documents bundle, tab 85, at page 3357, paragraph 34, where we deal with the attempted analogy with schemes of arrangement, which is a company law matter often used to deal with the internal workings of the company. And can I invite the court to read paragraph 34 on page 3357, going over to page 3358. I go next then to the concept of the single leading court, which the appellants rely on, and that's dealt with in our Annex 2 at page 3379 at paragraph 4. First of all, invite the court to read paragraph 4. 3379. Paragraph 4. Now, I want to make the point that in the concept of modified universalism, which is not an exact concept, it's universalism with some modifications, but modifications are different in different countries and different cases. Just to go back track back to universalism, if I may. One actually starts with unity and the idea that in an ideal world, one debtor has his affairs, insolvency proceedings, restructuring, whatever it is, dealt with in one jurisdiction under one law for all aspects. That's unity.
As under the Winding Up Directive.
Yes. Yes.
For another month at least.
Universalism then says on top of that, where you've got hopefully unity as an ideal, also as an ideal, the effects of that one proceeding are recognized everywhere throughout the world and given effect to. That's universalism. Modified universalism, as the name suggests, is that actual universalism is not in fact achievable in the real world, certainly hasn't been, and has to be modified in some way. But it's kind of on the way, it's on the trajectory towards universalism. Now, in the concept of modified universalism, what we say is that a single leading court is not the same as a single court. A single leading court is actually helpful to our case, not to the appellant's case, because it emphasizes the fact that in modified universalism, there is a role for other courts to support the leading court. And that is exactly what, in this case, the United States Bankruptcy Court is doing. It is supporting the BVI court by exercising jurisdiction over persons over whom we certainly consider there may well not be jurisdiction in the BVI. Just on that point for a moment, my friend Lord Faulkner says, oh yes, there is, you can serve out. Well, this is sort of the theoretical world and the real world. In the theoretical world, you can serve out against everybody. In the real world, of course, you're not going to get much change out of serving out in many cases, depending on where people are and whether they feel that you're able to reach them in that jurisdiction. And from that point of view, the US jurisdiction is particularly useful because anybody who uses or spends dollars at some point has to go through the United States. And of the 700 plus financial institutions that we're suing in the United States, of course, a lot of them, as Mr. Chris's evidence said, as we saw, a lot of them have a principal place of business in the United States. So there is an important role, even if we think of the BVI court as the leading court, there's an important role in the US court being the ancillary court, and Chapter 15 is described as ancillary proceeding, as the old Section 304 was. The next point is that the appellants rely on the concept of modified universalism and say that their submissions are in accordance with that. And we say again that actually that concept militates against their submissions and against any prohibition on foreign courts exercising BVI avoidance powers. Because in modified universalism, the assistance of foreign courts, as I've already submitted, with personal jurisdiction over defendants, is a necessary aid in exercising jurisdiction and making the law of the main proceeding, main insolvency proceeding, making that law effective in other countries.
Because the effect of modified universalism is that you can't take jurisdiction to enforce unless personal jurisdiction has been established. And that may be a problem for the liquidator in various parts of the world.
Precisely, my lady. Now, the appellants have relied on the original model law. I'm going to distinguish that from the new model law, because there is also a new one, which I'm going to mention briefly in a few moments. The appellants attempt to use the original model law as a tool for interpreting the BVI statutory avoidance provisions. There are serious problems with that, not least the fact that the BVI statute contains a version, an enactment of the original model law, which is not in force. And so the BVI legislature has not seen fit to give effect to the model law at the time that it gave effect to all the other parts of the 2003 Act. The background to this is that there are essentially three types of cross-frontier assistance, foreign insolvency proceedings, in relation to avoidance actions. Now, if I remember correctly, these are set out in the Condor case. Type 1 is where the court receiving the request from the foreign court or liquidator, we call it the receiving court, may have power to apply its own avoidance law. That's type 1. An example of that is English judicial assistance at common law, the Singularis case. It's in the bundle. Another example of type 1 is the British version of the original model law, and that is explained in the Pan-Ocean case that's in the bundle. The second type of case is where the receiving court can only apply foreign insolvency avoidance law. This was a position, first of all, under the old Section 304 of the US Bankruptcy Code, as exhibited by the Metzler case, as interpreted by the Metzler case. Second example is the position under Chapter 15 of the US Bankruptcy Code, which applies in the present case, as interpreted by the US case law, such as Condor and Hellas II. This case 2 approach is actually the most logical and the most universalist, because as I explained earlier this morning, it treats everyone equally. The proviso under Chapter 15 is that you can apply US avoidance actions, but only if you start a US plenary proceeding. So it's not a genuine exception. The third type of case, case 3, is where the receiving court has a choice of applying either its domestic avoidance law or the foreign insolvency avoidance provisions. That's the position under the UK Section 426 and BVI Section 467 sub 5. For present purposes, the important point is that there is no one standard approach. completely contrary to the thesis of the appellants, there is no one standard approach with which to interpret the Insolvency Act 2003 and BVI. The original model law is only one model law. It's only a model law. It's not a statute. It's not a treaty. It's not a convention. It's a model law. It's voluntary. Its adoption is voluntary. It can be adopted with modifications. It has been adopted with modifications. There's a fundamental divergence in the method of adoption, for example, as between Great Britain and the United States. Contrast for Great Britain, the Rubin case and Pan Ocean case, which say that you can't use the model law to import foreign law. Contrast that with the US, Condor and Ellis II, which say you can import foreign law under the model law. The appellant's argument also, very importantly, ignores Article 7 of the original model law, so it doesn't suit their case. Article 7 says, in effect, that the provisions of the model law, which UNCITRAL invite every country to adopt, are to be in addition to, not to take away from or overturn or replace, the pre-existing methods of cross-frontier insolvency assistance. Now, this country adopted Article 7, as more or less as written. And so we have saved common law assistance, we've saved Section 426. So the model law really is an additional option, an additional weapon in the armory. The United States, by contrast, did not adopt Article 7 in the way the original Article 7. And they have said that the new Chapter 15 is the only method of cross-frontier judicial assistance. But for present purposes, what matters is that the original model law is not the one single model of approach that the appellants claim, and does not help to interpret the provisions we're looking at in the BVI Insolvency Act 2003. Now, there is a new model law, very recently adopted. Because it's very recent, we submit it cannot assist this court in interpreting a 2003 statute. But just to inform you as to what it is, UNCITRAL has put forward a new model law on the recognition of insolvency-related judgments, primarily to overturn the Rubin case, which they don't like. Now, as far as I'm aware, no country has yet adopted the new model law, and it's a sort of, we'll see in the future what happens type of situation. Absolutely no relevance to this case. I mention it only for completeness. Now, finally, I want to pick up a few points from the speech of my learned friend, Lord Faulkner, if I may. Lord Faulkner mentioned the question of interfering with commercial relations. If we attempt to be a little realistic about this, given that BVI is a small country, many companies nearly all of which do business entirely outside BVI. The realistic position is that contracts and counterparties are not going to be BVI contracts and counterparties. They're more likely to be New York law, English law, and to be resident anywhere else in the world but the BVI. So it is highly improbable that the BVI courts would want to insist that it is only BVI law that can have anything to do with the insolvency law effects on foreign counterparties and foreign law contracts. And the BVI courts, I'm sorry. Lord Falkland next suggested that the liquidators could bring US Chapter 11 or Chapter 7 proceedings and use American avoidance provisions. Of course, again, in the real world, given that all the events happened before 2009, there could be slight limitation problems if somebody tried to do that now. And it's not really an answer to the issues in this appeal. Incidentally, it is also a case, of course, that there would now be a probable time bar in the BVI itself if anybody tries proceedings there. Learned friend referred to investors in the BVI, and that I think he said they invested in the BVI court's right to set aside transactions and not the US court's rights. Now, in investing in the BVI and dealing with a BVI entity, of course, one would expect probably a BVI insolvency proceeding, but that's not the same as where you necessarily end up getting sued. We would respectfully suggest that an investor who's a counterparty, if they thought about it at all, they thought, where are we likely to be sued? The answer would be, we'll probably be sued in our jurisdiction, in our domicile. It's not going to be the BVI. Learned friend Lord Faulkner suggested that if the US court is to assist the BVI court, it should apply its own avoidance law. Well, as we've seen under Chapter 15, it can't unless you start a plenary proceeding. But, as interpreted by the US courts, it can apply BVI law. Learned friend referred to a series of types of order which he says can only be made by an English court, Part 7 transfer, disqualification, and so on. If one thinks about these examples, they are never going to happen in the real world. No US or other foreign court is going to try and decide a disqualification matter or a Part 7 transfer. So it's an entirely hypothetical question, and it is easily answered by the phrase not appropriate rather than forbidden. You don't have to imply anything in the statute to say this can't be done. It is simply not appropriate, and everybody would, but hopefully abroad also, would recognize that these are not appropriate things to do. Learned friend said there's no authority applying BVI law in a foreign court. But we do have something similar, which is set out in our case, in the English Court of Appeal case of England and Smith. Although it doesn't actually discuss the point, it wasn't argued, we say because it's blindingly obvious, Nevertheless, it is an illustration of exactly what we're saying. If we go to our case, please, at Documents tab 85. It's a discussion of England and Smith between paragraphs 24 and 28.
You've got a convenient page number.
Yes, 3352.
Thank you.
It's paragraph 24. And can I invite the court to read paragraphs 24 to 28? We say that this is very close to our case. So we have the power, as one has in the BVI, to apply either the domestic law or the foreign law. The foreign statute uses the phrase "the court," and unsurprisingly, as a statute addressed to the Australian courts, the court means various Australian courts. This is also a discretionary power, expressly, as one can see from the extract, page 3353. So England and Smith, although as my own friend would say, it's an incoming case, but if we look at it from the point of view of Australia, it's an outgoing case. So the Australian court, even though it's defined the court as being various Australian courts, not English courts, nevertheless, via Section 42, the powers of Section 426, which empower the English court to use either English law or Australian law, to ask the English court successfully to exercise powers, choose Australian law as being the more appropriate law, and then apply that in a discretionary way to the case. Now, the only way in which the appellants try to distinguish this case is by saying, well, Section 426 says expressly you can use the foreign law. The difficulty for them is that, of course, although Chapter 15 of the US Bankruptcy Code doesn't say that expressly, that is how it is interpreted by the American courts. So it might as well have said expressly, just as Section 426 does. And therefore we say England and Smith is a very good working example of exactly the situation that we're talking about, and how this is not in any way contrary to the statutory policy of Australia, England, BVI, or any other country. Learned friend suggested that we don't allow foreign courts, if I've got this noted down right, we don't allow foreign courts to apply our avoidance provisions unless there's an international agreement. Wrong, I'm afraid. And in relation to Section 426, there is no international agreement. And model law isn't actually an international agreement either. Just finally, I must to remind you, although I may have mentioned it before, that Chief Justice Pereira, in paragraph 79 of the ECCA judgment, points out that BVI public policy is in favour of the US courts applying BVI law. Of course, as I've submitted earlier this morning, that, of course, is also a more complete version of universalism and equal treatment for all creditors. Now, unless I can assist the board in any other way.
Thank you very much indeed, Mr. Moss. Mr. Midwinter, do you follow? Lord Faulkner.
I'm obliged, my lord. Can I deal with 10 points in reply? First of all, the point made by my learned friend Mr. Moss that there's no basis for interfering because there's no error on the part of the Eastern Caribbean Court of Appeal, which is the Hadmore point. I submit that if our submissions are right on construction of Section 249, then there was plainly an error on the part of the Eastern Caribbean Court of Appeal, and that would justify interference by this court in determining whether either to grant an anti-suit injunction or to grant a declaration. Secondly, in relation to standing, can I deal briefly with the point in relation to standing? I am being, on one view, sort of got at both ways. Lady Arden asked the question of Mr. Moss, well, they couldn't, you couldn't, obviously it would just be a busybody who would apply under Section 273. At the same time, complaint is made that no attempt was made to set aside the order that was granted as between the liquidator and the court. I submit that we have standing to apply for a declaration if it would serve a useful purpose. I submit that we have standing to apply for an anti-suit injunction if we can establish that an interest or right of ours would be being interfered with. My lord, just to test that, although this is not what we say, suppose that an section, in addition to Section 249, had said words to the effect, and the liquidators shall not bring avoidance proceedings in any other court apart from the BVI High Court. Could a person against whom such proceedings were brought in another court, a foreign court, seek an injunction? Answer, yes, they would, because the effect of Section 273, i.e. the busybody code, is not intended to deprive applicants or outsiders, i.e. busybodies on one view, but not part of the insider group in corporate insolvency. It doesn't prevent them from bringing what legitimate claims that they've got.
But you are, in effect, founding your objections and your application for relief on the basis of grounds related to the decision of the liquidator to take proceedings in New York. It's not an independent view that comes out of the circumstances of your own particular case. It's a challenge, really, to the liquidator's decision.
It comes out of my client's particular case, in the sense that we submit, we as a defendant should not be subjected to a Section 249 claim abroad. Yes, my lady is right when she says that's attacking a decision of the liquidator, but equally and separately and sufficiently for jurisdiction, I am also saying I should not, as a defendant, be subjected to such a claim. And that gives me a right, as somebody other than part of the insider group, that can bring a Section 273 claim. But I respectfully submit that the bar, in a way, in any event, partly for the reasons that my Lord Hodge said in the course of argument with me yesterday, the declaration would be sufficient, probably, in these circumstances, both to determine what happened vis-à-vis the US, but maybe equally what may happen in relation to what the BVI court would then do with the permission it had given to the liquidator. My Lord, I'll pick up, if I may, later what I say the useful purpose is, but it's pretty obvious. My Lord and my Lady, there are, in our respectful submission, two relevant questions in relation to the appeal. The first is the useful purpose question. We submit that there obviously is a useful purpose in describing what the effect of Section 249 is, because of its significance and importance in the decision that His Honour Judge Bernstein reached. See page 41 of his judgment in December, which we've looked at quite frequently. And, my Lord, it is my learned friend was submitting that actually there were other things maybe in the back of his mind, and there were other bases on which it could be said he reached that conclusion. I respectfully submit that the court should not go behind the reasons that he gave, and as far as he was concerned, that decisive, indeed the only reason given, was what the ECCA had decided in relation to the case that they had heard before them. And that makes it clear it would serve a useful purpose. Because if the decision had been different, it is reasonable to suppose that there might have been a different result. My Lord, the second question on the appeal is then what is the correct construction as a matter of BVI law of Section 249. My Lord, in his submissions yesterday, my learned friend submitted that the underlying issue is whether the US courts, under US law, have the power to use BVI statutory avoidance provisions. And I've taken that from day 1, page 102, lines 11 to 13 of the transcript of yesterday. In my respectful submission, that is not the issue in this court today. The issue arising in this appeal are concerned exclusively with the question of statutory construction relating to the operation and scope of Section 249 of the BVI Insolvency Act. The question and effect of Section 249 is a question of construction of a BVI statute, which is a matter most appropriately addressed by the BVI courts. My Lord, once this court has given a definitive ruling in relation to that, then it may be it's a matter for the US courts to decide what effect that has in relation to how they then deal with it. But it is critical, I respectfully submit, in relation to this, to focus on the fact that this court is not deciding what the US courts might do in the light of any declaration or order made by this court. My Lord, as you know, our basic submission is that the effect of Section 249 is to confer a right on an office holder in a liquidation under the BVI Insolvency Act. It gives that officer a right to apply to the BVI High Court, and it confers a corresponding power on the BVI High Court to grant relief on such an application in respect of avoidable transaction. In this regard, we say, unless and until an application is made and unless and until the court grants the sanction, the relevant provisions have no substantive effect on the rights on any other persons. Whether or not the US courts under US law can apply or give a remedy in connection with an avoidance provision of this sort is an entirely different issue, and it's one for the US courts to decide. But we say that decision that the US court made should be made on the basis of a proper understanding of Section 249. My Lord, I've indicated why I think it would serve a useful purpose. I've gone through the points about speculation in relation to what was in Judge Bernstein's mind. One of the things about judges and judgments is that they should be taken to express their views in judgments rather than by trying to ascertain what they might have been thinking on the basis of what might have been said to them at particular times. My Lord, can I move? I've dealt with standing. What are the issues on this appeal here? Fourthly, questions of useful purpose. Can I deal very briefly with the question of the US decisions? First of all, before I get to the individual US decisions, it is important, when your lordships have an opportunity to read the ECCA judgment, there is a reference to these US judgments, but the way the submissions went, or the way that they were treated by the ECCA, it's as if they, the ECCA, were being asked to make a decision of US law. Can I just refer you to it briefly? If you go to it's Bundle 1, for 18. Page 207 in the electronic bundle. 207. If you, I don't ask you that, but if you just cast your eyes over it, you'll see that and I'm taking 67 as an example, the appellants further point to a ruling by the US District Court which is held. The appellants further contend that the fund's reliance on the two cases, namely Atlas and Condor, are supporting the motion that there might be some power in the US court. And then they consider the cases. And then if you look at 72, the funds then refer to England and Smith and then refer to Atlas and Hellas. And it's like the court is being asked to make a ruling, paragraph 73 is the same, very much as to what the US position is. And that's not the function of the court. Myself and Mr. Moss, who were the aiders and abettors of the Court of Appeal in the decision that they reached, there were other counsel as well, may be guilty of spending too much reliance on these cases. But if you look at those paragraphs, it almost looks like they're trying to resolve US law, which they should not be doing. The significance of US law in this case, in my respectful submission, is it can provide no more than the facts in relation to this individual case as to what the impact of a judgment may be by this court, and that's in effect page 41 of His Honour Judge Bernstein's judgment, but also it provides some indication as a matter of authority of the way that the US courts have looked at cross-border insolvency cooperation. I don't intend to refer to any of the cases except for Seismic and Hellas. I say this about Atlas. Atlas is a case where, in effect, His Honour Judge Glenn, the US Bankruptcy Court, said that the US courts would be willing to, in assistance to a Danish bankruptcy, discharge a maritime attachment that a creditor had got. And the reason why they're willing to do that in the US court is because the maritime attachment, in effect, was contrary to the scheme of the Danish bankruptcy, because it would give the people with the benefit of the attachment an unfair advantage in advance of all the other creditors.
In relation to what I'm making, but it was not both of us who invited the ECCA to make a decision US law.
Well, it's paragraph 66, the first three sentences. Yes, I picked that up.
I was willing to take some of the blame, but not all of the blame entirely on my own, because they replied, look at para 72.
Yes.
So we both stand before you guilty and throwing ourselves on the mercy of the court here in relation to that. I also submit that if you look at the first sentence of paragraph 66, that's the prime submission.
But the court itself only thought that it had to reach a view that it was arguable as to what US law was.
Yeah.
That would be quite proper, wouldn't it?
That would be yeah. If the position was that it could be shown that it's completely unarguable as a matter of US law, and I'm not saying that. I'm not saying that, but I'm saying one's got to be careful about the way that one looks at these US cases. So I say Atlas is about maritime attachment and has effectively nothing to do with avoidance provisions. Condor is a case, in effect, concerned with the Statute of Elizabeth, and is therefore talking about an individual's right, not a collective right, and therefore it doesn't tell you whether or not, as a matter of construction, Section 249 would be construed in the same way as they construed the Statute of Elizabeth, which is the equivalent statute that applied in Nevis. And then if we go to Hellas, can I submit what Hellas appears to be saying? It appears to be saying that the bankruptcy court has, quote, subject matter jurisdiction as a matter of US law, which has to depend upon US statutes, not UK statutes. It says it takes the view, on the basis of evidence, that Section 423 is procedural, not substantive. It then goes on to say, but even if it was only procedural, although there is no definitive precedent in the UK, we think we could still apply it because of the cross-border insolvency regulations and because of Chapter 15. Could I just take your Lordships to look at Hellas, which is in, hold on, Bundle 5, Volume 4, sorry. 4475. If you go to 566, sorry, 4498, apologise. Do you see the court has already held that it is subject matter jurisdiction over this adversary proceeding under 1334B of Title 8, of Title 28 of the United States Code. And that is no more than a finding, as is reflected in the Seismic case, which we'll look at briefly, that where you're dealing with bankruptcy, the US federal courts have got jurisdiction. And then if you go to 9, the court's conclusion that it is subject matter jurisdiction over the section 423 claim is bolstered by the following additional observations. First, section 4234 of the Insolvency Act appears to be a procedural venue provision clarifying where a section 423 claim may be brought in the UK. So they hold, as it happens, that section 423 is venue only, not substantive. While the court is bound to apply the substantive law of the UK to adjudicate the section 423 claim, it's not bound to follow the UK procedural law. That suggests that had they found it was substantive, by which I take it to mean that if the position were that it's only the UK court that can give this relief, because the relief and the court are bound up together in the way I submit section 249 is, the US court will be bound to apply it.
Where you draw the line, though, between substantive law and the procedural law of lex fori is itself a question of private international law, which a US court would be a question of US private international law.
Yes, that's right, but there is an issue which His Honour Judge Glenn rightly recognises as being a matter of English law in that case, I say BVI law in this case, which is what is the nature of the right that the foreign law is creating? Is it intended to be exportable? If the effect of the foreign law, when you're being asked to apply foreign law, is that it's not intended to be exportable, then that would be, one would have thought, a very strong indicator that the foreign court's private international law should not give effect to it. All the more so where you are dealing with cross-border insolvency. So take the absolute classic example. You could not make an English winding up order in a US court. And why is that? Because it is perfectly plain that the English statute in creating an English winding up order does not intend that such an order should be made by a foreign court. The other side of the coin is the section 172 of the Law of Property Act type provision, which says that where somebody fraudulently prefers one creditor to the detriment of another, that is creating a freestanding legal right which anybody can see is intended to be exportable. Now, in my submission, it would be utterly obvious in relation to section 249 that it is not intended to be exportable. The reason why it's not intended to be exportable is threefold. First, the wording, though for all the reasons that Lord Briggs gave to me yesterday, that's not conclusive for obvious reasons. Secondly, because this is part of a collective process which the English court, or the BVI court, is in charge of. And thirdly, because the extent of avoidance provisions are very much a matter for the public policy of the local jurisdiction. What makes this difficult, what makes it unusual, is not the nature of this right, which I respectfully submit is obviously not exportable, because it's not like, a civil code gives a person a right not to be negligently run over, and that's obviously exportable. A contract gives somebody a black letter law right not to have a contract broken. This is obviously part of the English law's approach to collective insolvency. What makes this odd is because of the way the courts have operated in relation to cross-border insolvency, which means that what they are dealing with is taking rights that are collective rights and therefore are difficult to export and asking what you do in a foreign court with those collective rights. And Mr. Moss rightly drew attention to the fact that a variety of solutions are reached in relation to this. But I respectfully submit the way this court should approach it is to say this doesn't look on the face of it exportable. What the legislature had in mind in relation to this is it's part of the collective insolvency arrangements. It might be that US law allows it to be exported, but as is plain from US law and as is plain from English law, there are certain sorts of right that are not envisaged to be exportable, and avoidance law is I submit, a classic of the genre of non-exportable rights. That does not mean that there won't be some circumstances in which these rights can be exported. And I cited yesterday the classic in English, not English, but sort of English private international law, which is the EU insolvency regulations, where Article 7, but subject to the protections in Article 16, make avoidance rights exportable. The model law indicates that by and large, there were great anxieties about making avoidance rights exportable. Can I just refer you to the discussion just before the conclusion of the model law? If you go to Bundle 5 in the record, Flag 61, what you're looking at in 61, it starts at 1209. It's the final discussions in the United Nations Commission on International Trade Law. It's 30th session, that's 1209. And this was the last discussion that they had before they agreed the model law. Now, I'm not asking you to look at this in order to help construe section 249, but to provide the thoughts that underline the policymakers when they're thinking about avoidance provisions. And if you look at 1254, they are discussing what do you do about avoidance provisions. If you look at the provision they're talking about, do you see it's called Article 19 bis?
Yes.
That, in fact, is what became Article 23 in the final draft of the model law, which you can see if you look at 1286 of the same bundle, of the same document. But I would just invite your Lordships and your Ladyship to read from 210 to 216 as to what the nature of the debate was. And, my Lord, I don't ask you to look at it now, but if you ever had the opportunity to look at the Vergosh-Schmidt report, which is the travaux préparatoire to the EU Insolvency Convention, paragraph 135 to 139, you will see what the thinking was which led to the solution that was given in the EU insolvency regulations. And essentially, what both the debate before the production of the model law and the debate before the production of the EU insolvency regulations was produced amounts to is saying, look, there are obviously difficulties about allowing one court to give effect to the avoidance law of another, the solution reached by the model law, on the face of it, looks like you can only apply the avoidance provisions of the receiving court, though that is not the view that ultimately the Chapter 15 applied. The solution that is given in the EU insolvency regulations is you can apply foreign insolvency law, but only subject to protections, and very specific protections are given in the articles of the EU insolvency law.
Looking at paragraph 215 on page 1254, it looks as if, at any rate at discussion level, they ended up not taking a stand either way as to which law should be applied.
Or it's understood that the provision should only confer standing to bring actions under consideration. In particular, it should not create substantive rights and should not take a stand as to which law was applicable.
Yes.
So what they're saying, as I read it, is we are not, by the model law, giving people the right to bring the avoidance law of one country in another country. But if the position is it exists under their private international law already, we're not going to interfere with that. It is only dealing with procedural matters. And if you look at the wording of the clause that they agree, because there's a drafting group subsequently, look at Article 23 in 1286. Upon recognition of a foreign proceeding, the foreign representative is standing to initiate refer to types of action to avoid or otherwise render ineffective acts detrimental to creditors that are available in this state to a person or body administering a reorganisation or liquidation. So it's not giving an additional substantive right. It's referring to the rights in that state. That will include any rights that they've got under private international law. It can't be taken as meaning that it gives them the right under the code. It might be there separately, but under the code to bring the avoidance law of a foreign country.
Could you give us the reference, please, for the Travo paragraphs to which you referred?
Sorry, yes. They are, it's in the document, the report of the United Nations Commission, which is at bundle 5, flag 61, starts at page 1209, and the discussion is at page, 1254. I don't know how I got into that, but I sort of dived out of Hellas into that.
One way of looking at 23.1 is types of action. It's just a sort of broad heading at a high level of generality, so that if a requested state has a type of action which can loosely be called the setting aside of wrongful preferences, then the foreign representative come along and ask for assistance. But that doesn't answer the question as to which detailed law should then be applied.
No, that's true. But all I'm saying, you were putting to me, I thought, that this doesn't make a choice.
Yeah.
And I'm putting back to you, and you may be resisting. Well, you're not. I don't think. I'm sure you couldn't resist the proposition I'm making, which is that this code doesn't give the U.S. courts the right to apply foreign avoidance law.
All I'm saying is it doesn't. Article 23 doesn't foreclose the question any more than paragraph 215 of the discussion.
No, and what I was trying to do by citing this was to show, look, these are the sorts of considerations that apply. It would have been very odd, I submit, if one goes back to section 249, that they, without international agreement, had been minded to reach a conclusion that section 249 was intended to be exportable.
But there's another way of looking at it and analysing it, isn't it? That is, it's a distinction between procedural and substantive.
Yeah.
And that's paragraph 9 of Hellas 2. And the way the US court has analysed it, as they are entitled to do, that the provision relating to the meaning of the court is a procedural provision according to their characterisation of substance and procedure, and therefore they can use their own determination of what is procedural.
Yes, I accept that it's as it were US laws or US principles of private international law that will determine whether it's substantive or procedural. But what I am saying is there is a BVI question of construction as to what was the intention of the legislature in drafting and putting Section 249 in the way that it was. If the intention of the legislature was that this should only be applied by the Section 249 court, whilst that is not determinative as far as the US court is concerned, it will be of considerable assistance to them, all the more so when the material that they have exclusively based their judgment on is the Eastern Caribbean Court of Appeal decision that said, as a matter of BVI law, it was procedural rather than substantive, i.e., the way that the Eastern Caribbean Court of Appeal construed the section was to say that it was readily exportable. That was the effect of their conclusion, and I respectfully submit that that is wrong, and that is an error that should be put right.
But even if they had said the opposite, it would still be open to the US courts to analyse it according to the law of the forum.
It would be, I agree.
Yes, that's the second half of paragraph 9. Yes. In Hellas.
Well, I agree with what Lady Arden has said. In relation to the second part of paragraph 9, I read that as saying that the court is bound to apply the substantive law of the UK. It's not bound to follow the UK procedural law. I read His Honour Judge Glenn as saying there, if it was a part of the substantive law of the UK, that Section 423 relief could only be given by the UK High Court, I think it was in that case, then we, the US bankruptcy court, would be bound to follow that, assume that we agreed that that was UK substantive law. That's a rather odd bit of his judgment.
If there is still this question as to whether or not it is US law or BVI law which determines whether it's substance or procedure.
Yeah, I'm accepting that it's US law that determines whether they view it as substantive or procedural, but my case is they would be greatly assisted by what the ECCA said, and they've been, I say this with respect, they're proceeding on a mistaken basis because of what the ECCA said.
Well, in Hellas 2, the judge founds on the restatement of conflict of laws, and he quotes it saying, "A state may entertain an action even though the state of the applicable law has provided that action on the particular claim shall not be brought outside its territory." So I don't know how you can reconcile that with your description of what was the meaning of the second half of paragraph 9.
He says, in actions where the rights of the parties are grounded upon the law of jurisdictions other than the forum, I don't think it's inconsistent at all with what I'm saying, is it? Where the rights of the parties are grounded upon the laws of jurisdictions other than the forum, it's well-settled conflict of law that the forum will apply the forum substantive law, but will follow its own. I mean, that's not inconsistent at all with what he's saying, what I'm saying. The question is, what is UK substantive law and what is UK procedural law? All that he is citing the restatement for is to say we here in the US will not follow or be bound by UK procedural law. The question is what is procedural and what is substantive. And that is the question that he is looking to an answer for.
Yes,
I agree, and I understand that it's... Sorry, I apologise for interrupting.
No, I wanted you to finish the sentence. Sorry, I didn't mean to interrupt.
I don't think by that I'm disputing the proposition that it's US law that determines what's substantive and what's procedural, but equally, just to finish this point, if you go to 569, the bottom, it's 4501,
Which column?
the right-hand column, do you see this adversary proceeding? the court has been unable to look at any equally determinative UK precedent addressing whether Section 4234 is an exclusive jurisdiction provision. Now, I cite that to indicate that although I completely accept Lady Arden's formulation as to the fact that it's a matter of US law, completely understandably and legitimately, His Honour Judge Glenn was looking for the UK laws to determine what the answer to that was. He couldn't find a determinative precedent because there wasn't one, so he had to reach his own conclusion in relation to it. And that's, I submit that's not in any way there's no conflict between His Honour Judge Glenn having to decide the point in accordance with US law and being primarily guided, if he could be, by a UK ruling in relation to that. And that's exactly what's happened here as a matter of common sense. It's the ECCA's ruling that has been determinative. His Honour Judge Glenn was looking for one in Hellas, but there wasn't one. So he had to do the best he could. And he reaches a conclusion. But it's implicit in that even accepting that it's ultimately a matter for US private international law, as to whether it's procedural or substantive, of course, if the UK courts said it was substantive, he'd follow that. So, I mean, are we dancing on the head of a pin?
Well, he doesn't seem to be saying that, because he seems to be saying an exclusive jurisdiction clause is a matter of procedure for US law purposes. Is that?
In the course of his judgment, he treats the question of whether it's substantive and whether it's an exclusive jurisdiction clause as quite as interchangeable.
Well, does he? Because if you go to the second half of paragraph 9, where he says, in terms, neither Isaacs nor Moss have identified any English decision indicating that Section 4234 is an exclusive jurisdiction provision. However, even if Section 4234 were an exclusive jurisdiction provision, this court is not bound to enforce it.
Yeah.
What basis could there be other than the conclusion that in US private international law such a provision was procedural?
Well, can I answer that by saying what I think he's saying? If you look at paragraph 9, he's saying we'll apply UK substantive law. That's the first bit of paragraph 9. Then he says, second, neither Isaacs nor Moss has identified any English decision indicating that Section 4234 is an exclusive jurisdiction provision.
Yes.
I initially read that as meaning it would be substantive if it was an exclusive jurisdiction clause, but he then goes on to say, by reference in particular to Randall and seismic, that we can nevertheless, in our courts, get round exclusive jurisdiction clauses. So, is it just an assertion in paragraph 9 that it's procedural, not substantive? And then the exclusive jurisdiction stuff is a different part of the reasoning?
Well, the passage he cites from the second restatement on conflict of laws seems to suggest this is a recognised doctrine of US private international law.
Well, that may be in relation to exclusive jurisdiction clauses, but is that separate? I'm not asking for an answer in relation to this, but I read him as saying, happily it's procedural, not substantive. That's his first paragraph. Secondly, and this may be an alternative point, though I initially read it as being the same point, actually there's no decision and nobody can find a decision as to whether it's an exclusive jurisdiction clause or not. If you go to the seismic case, and I'm getting a bit sort of far away here from, because one thing I'm asking you not to do is to reach a conclusion in relation to all of this, and I who knows what this means. I'm not disputing that it's arguable that as a matter of US law, that it might be that they could apply BVI avoidance law. I should not be taken in saying that I accept that they can, but I'm saying that this court, not a US court, can't rule out the possibility. It may well be that those representing my clients in America would like to say they shouldn't apply it, but I can't say in this court that that's not a possibility. If you look in seismic, and again, I don't want to take you all through, because I'm getting very short of time in relation to this.
Yes.
What seismic is about is a company law case. The 10th Circuit, the 9th Circuit say, in effect, we've got jurisdiction to hear this case because it's about companies, it involves a foreign person, and that gives them jurisdiction, but we won't allow the case to proceed because the only court that can give relief is the Alberta court. And even though they describe it as an exclusive jurisdiction clause, what they're doing, in effect, is saying the only court that can give relief is Alberta, so we're not going to bother with the case. That's not the right word, but they're not going to allow the case to proceed. Now, if the position is here that even though the bankruptcy court has jurisdiction because it's a bankruptcy case, but they conclude that it is only the English court that can give relief, or the BVI court that can give relief, which is my submission, then one way or another, this court should say that, and on the basis of seismic, that would be an end of the matter. Now, it may well be that the US court would not take that view, but this court can say what the section means and what was intended. What you can't do, in my respect, what I respectfully submit you shouldn't do, I mean, you can do whatever you like, but what you shouldn't do is say, well, because it's exclusively a matter for US law as to whether it's substantive or procedural, we will express no view in relation to it. In my respectful submission, it would serve a useful purpose for this court to say what was the legislature's intention in relation to that. Is it like the winding up order, or the director's disqualification order, or the transfer of books under Section 111, insurance books and banking books, where it was not intended that any other court other than the BVI court should give effect to that. My Lord, that's all I want to say on the US decisions. My Lord, I think I've put you understand what my point is as a matter of construction. You understand how I put the point in relation to it. As far as abuse, this is the 7th point, is abuse. I submit in relation to abuse that we are not in any way refusing to be bound by a decision either of the BVI High Court or the BVI Court of Appeal or this court. And that, as my Lord Briggs said, we must be entitled, while these applications are being heard in this court, to seek to defend ourselves by taking a position in relation to the proceedings in the US. Nothing that we have said in any way involves disrespect or not accepting or being bound by the BVI proceedings. So we make submissions as to what the effect of the CCCA court decision is. We make submissions as to the fact we're appealing that decision. That in no way is abusive. The key element of abuse is trying to have your cake and eat it, which is to say we'll take this decision if it suits us, but that's not the position here at all. We completely accept it. So in our respectful submission, abuse doesn't even begin to get off the ground in relation to this. In relation to declaration, the key issue in relation to declaration is, will it serve a useful purpose? And in our respectful submission, it will serve a useful purpose. Points were made that this hadn't been asked for before, which is true, but the key benefit of the declaration wasn't fully apparent until the decision of His Honour Judge Bernstein in December 2018, which is between the Court of Appeal and this hearing. So the fact that no declaration was asked for before, first of all, does not prevent this court making an order. And secondly, in any event, facts have changed since the matter was last before a court in the BVI.
Is it really just as simple as that? One can imagine there must be cases all the time in the United States, for example, where issues arise as to English law. And the court will hear evidence from English lawyers as to what English law is, and it will make its decision. Yeah. Now, if instead you could cut through all that and instead begin proceedings in the High Court here for a declaration, it's a sort of analogous to a preliminary reference in Luxembourg, and try to the English court to tell the American court what the answer is under English law. And the declaration would serve a useful purpose, but it's not the function of the courts to give, as it were, advisory opinions to foreign courts.
Yes, I can see that. I still think it's a question of judgment as to whether or not, in a case like this, it would be sensible to do that. But perhaps more significantly, the Eastern Caribbean Court of Appeal have now given a ruling in relation to it. They never said, we're not going to give a ruling in relation to this for the sorts of reasons that your Lordship has put to me. You can't just leave it like that. We're not going to tell you whether it's wrong or right. We have a view, but we're not telling you. Because that would then lead to the Eastern Caribbean Court of Appeal, even if it was wrong, being the ruling precedent. And that would be a wrong conclusion to reach. My Lord, I was going to make submissions in relation to modified universalism, but I think I've made them in the course of my submissions in relation to construction. The last point was England and Smith. It's plain that England and Smith depends upon the specific words of Section 426 of the English Insolvency Act. In my respectful submission, that is of no assistance to this court in determining what Section 249 means. And the question, as far as Section 249 is concerned, is it intended that it should be exportable? Secondly, and separately in relation to that, Section 426, if your Lordships do find it of assistance in relation to construction, depends upon a request from the asking court to the assisting court, which in the case of Rubin, Lord Collins says is a very important protection, the request. And what you're doing there is two courts acting in concert together. Here, what you are dealing with is not a request by a court to another court. What you are dealing with is an office holder making an application to a foreign court.
With the permission of the BVI court.
But on the basis of what the BVI court was told the position is, and that is a very different sort of case to where the one court is requesting assistance from another. And Lord Collins did say in Rubin that it was a very important protection. My Lord, unless there's any other point I can assist your Lordships or your Ladyship with, those are my submissions.
Thank you very much indeed, Lord Faulkner. Well, we are most grateful to counsel on both sides for all the assistance that they have given us, and grateful also to those sitting behind them who have no doubt contributed to the research and the arguments. We'll take time now to consider what advice we will humbly tender to Her Majesty.